issues. DIG Lagat court cannot prefer cases against him. Kanja rejecting the handover of the payroll and the public participation on police recruitment. And joining me in studio is Dr. Amos Omolo, who's an advocate of the High Court. Thank you so much for making time. So there's an issue. The High Court has now given the Director of Public Prosecutions up to August 29th to now respond to a petition seeking criminal charges against the DIG of police, that is Eliud Lagat, over the death of teacher Albert Ojwang. And there's an argument here from the lawyers that the court lacks authority to compel prosecution, while the rights activists maintain that the evidence linking Ojwang. Is it true that the court lacks jurisdiction to direct the DPP? Is that entirely a DPP initiative and the court cannot intervene?
Yes, on the face of it, the Constitution and our laws vest those particular powers in the DPP to conduct public prosecutions. However, if you look at our historical context, in the past we've had cases where privately initiated prosecutions have been done by the citizens. So the question is, what happens if the Director of Public Prosecution fails to institute the proceedings? Should someone else be able to do that? And I think that is the question which is before the court. And the question now is whether or not the court can allow that kind of prosecutions. So yes, that is the position now. Yeah. And we are waiting to see which direction the courts will take on this particular issue.
Will it be a breach if the court pushes the DPP, so to speak, to institute the charges? Is there an issue of separation of powers that comes in there, or this is just a matter of semantics?
Technically, there may be no breach if you look at it from the context of unlimited jurisdiction of the courts to make various kinds of orders without undue regard to technicalities. So there may be no breach per se, but what may happen is that there could be other reasons probably that are not known to the courts as to why the DPP has taken certain positions. So sometimes it's not a matter of the fine print of the law, but you have to look at the context of the question. What is the problem? What are you trying to solve? And make the right decision. So sometimes intelligence information, for instance, is not available to the courts, and sometimes they may make decisions that may not be in the best interest of the country.
Yeah.
Yes.
What kind of evidentiary threshold is required for such a case where a blogger dies in a police cell at the Central Police Station, the person who seemingly accused him of a breach online, and the person who's allegedly aggrieved is a DIG, but he wasn't really there? So, you know, that's a tricky part of it all. There's an argument that he wasn't at the Central Police Station where the blogger died, in as much as he's the one who accused him of violations against him. What kind of evidentiary threshold is required for such a case?
Obviously, in a criminal case, we require evidence beyond any reasonable doubt. However, there are certain cases where circumstantial evidence can be used in a particular case. And let me give you the example. For example, if somebody died in a particular house, and at that particular time there were only 2 people in that particular house, then you can argue that there is irresistible circumstantial evidence to show that the only other person who was in the room may have been the person who committed the murder. But in this particular case, there may be no direct evidence linking the DIG to the crime, because he was not at the scene, and we have not seen any evidence to show that he gave specific orders that the particular blogger be murdered. Yes, so there may be no direct evidence, but it depends on how the prosecution may argue their case. Can they manage to convince the court that there is irresistible circumstantial evidence that shows that he is the one who is responsible?
Yeah. Yes. So that evidence beyond reasonable doubt, the case is cold. Is that what you're saying?
Yes.
Okay.
Yes.
All right, let me bring in Kevin Osido on this. Kevin Osido is Executive Director, County Governance Watch. Kevin, before you came in, we were just talking about the front page of the Standard, shielding Lagat. 20 Kenyans have now moved to court accusing President William Ruto, top security chiefs, and the Attorney General of shielding the Deputy Inspector General, Eliud Lagat, from murder charges over the death of whistleblower Albert Ojwang. Oh. Do you agree with this? On surface, is that the perception that it creates, that is being shielded, or is this a screaming headline?
Thank you so much, Trevor. Indeed, if you look at the expectation of the public, is that every Kenyan citizen would be protected by both the law and the institutions that are therefore supposed to ensure that the citizens are protected and that these institutions do their work. And the most exciting thing is that most of the faces that are on the front page of the Standard are faces that also belong to what is called the National Security Council, where therefore critical concerns of security should then be discussed and really be dispensed with. So in my view, the headline is not as screaming. It is speaking to the hearts of most Kenyans, particularly given the expectations that they have, that a Deputy Inspector General of Police, whether or not innocent or guilty as could probably be, you have certain responsibilities to the public to explain what therefore would mean this, would make this headline to scream as much. And therefore to the President, especially as the chair of the NSC, that is also embedded in the Constitution. Yes, I know the President has indicated that the institutions are supposed to do their work, but I believe that given the kind of mandate that he has, particularly through an electoral process, that he owes it to Kenyans to either explain or to demand from the individuals that proper explanations are given. And I agree with Wakili, only that sometimes our courts, Trevor, must do a lot of good work to redeem the trust and the hope and the belief that Kenyans have in the courts. And therefore, not just to say that, yeah, circumstantial evidence, he was not there, there is no proper explanation as to whether he sent or did not send people to, commit the crime, etc. But they owe it to the Kenyan citizens that all the institutions of governance, all the institutions of the criminal justice system, including the DCI, the DPP, among others, particularly DCI insofar as investigations are concerned, Kenyans are demanding for truth. Kenyans are demanding for accountability. Yeah. Kenyans are demanding that individuals whose names have been adversely mentioned, of course, given the concerns around Article 48, 49 of the Constitution, right of an arrested person, you are innocent until when you are declared guilty, etc. But the good book says, to whom much is given, much is required. At the level of the DIG, there is a certain expectation that Kenyans really have of these individuals and the institutions.
All right. Dr. Molo, there's also another issue here.